Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Hello, my name is Meredith and I'm a partner in the International Arbitration Group here at K&L Gates, based in London. And I'm speaking today with Professor Stephen Minas of Peking University School of Transnational Law, who is Director of Sustainability, Innovation and Law Circle. This is the second of a two-part podcast series looking at interstate arbitration. In the first podcast, we looked at some more general aspects to set the context, and now we're going to look at some more specific issues. Could I start with what role might interstate arbitration play in the war between the Russian Federation and Ukraine?
Yes, this is, of course, a very difficult question because when we do see violent conflicts between states, it can be very difficult for any particular legal process to resolve them. So what we're talking about here is the capacity for interstate arbitration to contribute to a resolution of a war. But I think it's, and history bears this out, it's very rare that a particular arbitral process will itself resolve an international dispute, such as a war between two states. Now, in terms of the current war between the Russian Federation and Ukraine, we have seen Ukraine resort to arbitration across multiple forms. In the realm of interstate arbitration, Ukraine has already launched two processes, two arbitrations under the Law of the Sea Convention concerning the conduct of the Russian Federation. Now, both of these claims predate the February 2022 all-out invasion of Ukraine by the Russian Federation, but they were launched in the wake of the Russian seizure of Crimea. And, of course, the sea surrounding Crimea is relevant to both of those cases. So, following the 2014 Russian aggression against Ukraine, resulting in the seizure of Crimea, two arbitrations were launched by Ukraine against the Russian Federation, both of which are at the Permanent Court of Arbitration, and both of which continue on foot to this day. One of them concerns coastal states' rights claimed by Ukraine and claimed to be infringed by Russian activities following the seizure of Crimea, interference in Ukraine's rights to the natural resources in the Black Sea and the Sea of Azov, and the consequences of what Ukraine claims to be the illegal construction of the bridge over the Kerch Strait. The other Law of the Sea arbitration that Ukraine has brought against Russia concerns the arrest of Ukrainian vessels, naval vessels, the detention of their crew, which the state of Ukraine argues to be inconsistent with the Russian Federation's obligations under the Law of the Sea Convention. Now, just to put this in context, as I said, there have been multiple state-to-state and investor-state legal processes launched by Ukraine. So from the perspective of Ukraine, and I certainly don't speak from them, but I think we can see that they're using the Convention of the Law of the Sea as well as other legal bases for seeking redress against the Russian Federation. And because of the compulsory nature of arbitration under the Law of the Sea Convention, it is a promising basis to launch processes against another state where the aggrieved state's rights under the convention are claimed to have been impugned.
Just looking at states other than Ukraine, thinking in terms of other Black Sea states, what other role might the law of the sea play in relation to the facts and issues that have arisen in the most recent conflict?
When we look at the Black Sea states, the states surrounding the Black Sea, we can say that there are interests in navigation, which have clearly been affected by the Russian aggression against Ukraine. And there is also an interest in the marine environment of the Black Sea and the obligation of all state parties to an obligation of due diligence to reduce, minimize the pollution of the Black Sea, as with any other area of the marine environment. So when we look at the consequences of the Russian aggression on the Black Sea, both human uses of it and the marine environment, these are problems that other neighboring states have an interest in too. Now, of course, Ukraine is perhaps the state with the most direct interest, but that is not to say that other states bordering the Black Sea do not also have an interest. If we take a situation such as the destruction of the Kakhovka Dam of just over a year ago now, what we saw in the aftermath of that event is significant pollution in the Black Sea, obviously more intense closer to the coast of Ukraine, but also significant pollution radiating out from the coast further into the Black Sea. Now, whether Ukraine would consider this as the basis for a further UNCLOS arbitration against the Russian Federation or not is not clear to me. But what is clear is that the Russian Federation has significant obligations concerning the marine environment, and events such as that certainly call into question whether the Russian Federation is abiding by those obligations.
Thank you. Just pivoting to another area that I know is a strong area of your interest, climate change. In what way do you see interstate arbitration being relevant to what's termed the road to net zero?
Well, the road to net zero, I think, requires us to explore the possibilities of all kinds of dispute settlement and all kinds of legal process, because we're clearly not on track as yet. Now, in terms of interstate arbitration, when the parties to the Climate Convention agreed the text of the convention in 1992, they foresaw arbitration as having a role, as well as interstate court adjudication. So arbitration was included as a voluntary form of dispute settlement under the Climate Convention on the basis that states could notify that they accept arbitration for any disputes under the convention. Very few states have so notified, and I think we can say that states do not want their direct obligations under the Climate Convention and the Paris Agreement to be subject to binding law-based dispute settlement, whether that's courts or arbitration. But that is not to say that interstate arbitration has no role regarding climate change and the road to net zero more broadly. What we've seen very recently, and again, I turn to the Law of the Sea Convention just because it does have that very strong jurisdictional basis for arbitration. What we've seen in the last couple of months is a very interesting advisory opinion of the International Tribunal for the Law of the Sea, which is very clear about the role of anthropogenic or human-made greenhouse gas emissions as a form of pollution of the marine environment. And therefore, contributors of anthropogenic greenhouse gas emissions, whether from land-based sources or from vessels, but pollution into the marine environment can entail international responsibility. In other words, one state can potentially bring an arbitration against another state saying you are not complying with your due diligence obligations in respect of marine pollution, either from your activities on your coastline or on your territory, or the activities of the ships that are registered to you that are flying your flag. Now, I hasten to add, of course, that an advisory opinion is not binding. It is not making the law, but it is suggesting a potential role for arbitration, as well as court cases, under the Law of the Sea Convention. And just in addition to that, another very recent development, the new High Seas Treaty, which was agreed last year and which has yet to enter into force, includes very significant obligations of states in respect of the protection of biodiversity in the high seas in terms of environmental impact assessments, the creation of marine protected areas, and so forth. And unlike the 1982 Law of the Sea Convention, which is far before climate change became a priority of the international community, climate change is built into the environmental provisions of the High Seas Treaty. And coming back to arbitration, the High Seas Treaty effectively cuts and pastes the dispute settlement provisions of the Law of the Sea Convention. So if we think beyond the coastline, beyond the exclusive economic zone, we also see interstate arbitration potentially playing a role in respect of the high seas. Now, beyond that, there are not many other bases currently for interstate arbitration as such concerning climate change. So it is a building block of the legal response to climate change. It is by no means front and center.
Thank you very much. Just looking at one final area of specifics, in what ways is it potentially relevant to the management of pandemics, which of course is something we've all lived through over the recent years?
Indeed. Pandemics are an area of potential legal dispute between states. When the pandemic started in 2020, there were various arguments about international responsibility and various claims that could have been made. What we have seen since then is that parties have responded or are endeavoring to respond on the basis of multilateral cooperation. So learning the lessons of the pandemic and entering into new legal arrangements to prevent pandemics and to strengthen pandemic response in future. So whilst arbitration does not currently have a role to play, it is interesting to note that in the draft text of the pandemic treaty, which is being negotiated by the parties to the World Health Organization, we see that arbitration is included in the dispute resolution clause, not with the force or the strength that it has in the Law of the Sea Convention, but including arbitration on the basis of parties agreeing to arbitration where a dispute arises. So parties seem to be willing, and again, this is only a draft text, but parties seem to be willing to contemplate arbitration concerning their commitments to cooperate in a future pandemic, but only on the basis of agreement. So it would operate effectively as either parties making declarations in advance of a dispute arising or parties going to arbitration following a dispute. Arbitration is already included in the current in-force international health regulations of the WHO, which are in some ways quite similar to a treaty. Now, again, this is currently notional. No party has gone to arbitration on that basis. But it does show that arbitration has a latent presence in the governance of pandemics. And if parties wish to utilize it, then they can. But again, this is something that has not been put into practice yet.
Thank you very much, Stephen. There's a lot of thought-provoking ideas and thoughts. Thank you very much for taking the time to speak to me.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.